Did you guys really think I wasn't going live? You must have thought that. Not legal advice. This is all opinion. I got to say that. And I'm going to talk about GTII. I'm going to give you, when I say I'm going to give you the latest update, there is stuff that's happened since in the last 30 minutes that I had no idea was going to happen. And it's very interesting for you guys, not for me, but for you guys. And anyway, I wanted to bring it up to speed so you know exactly what's going on. I'm looking at my phone because I'm also potentially going to get some type of message, but I will deal with that when the time comes. So not legal advice. Obviously, I'm just talking my opinion all. So make your own judgments. Obviously, by the way, if you recall, at some point in time with regard to GTII, I was threatened with a lawsuit. So just keep that in mind. So, of course, before I start going through GTII and I'm going to bring you up until 4 p.m. today. We're going to take you all the way up till 4 p.m. today. But before we go there, just a couple of things, and this is not typically how I do it, but I went to a building yesterday. This is true. Went to a building yesterday. It had something called an all-gender bathroom. I'd never seen that before, and I was confused. I went into the bathroom, and there was a urinal and a toilet. So theoretically, it could have more than one person. And I didn't know if I should invite somebody else in or lock the door. It was confusing because all gender could go in. I didn't know what you were supposed to do. Anyway, that's a real life example. I know it's very, very fun. Did you hear about the Supreme Court ruling about constipation? It was found to be unconstitutional. And last but not least, did you hear the recent headline that a Supreme Court justice got kidnapped by cannibals out in the Pacific? For lunch, justice was served. Anyway, so idea was here to kind of give you a full update as to what's going on with GTII. So now let me back up. So sometime prior to February, and again, all opinion, just talking my views, you make your own judgment, and it'll make much more sense when we get near the end. So sometime in, I think, 2023, I got started having communications with people who were questioning the actions of GTII. Starting in very early February, I had communications directly with GTI representatives, reached out to Mr. Rabari. We had, I think, one conversation, spoke to the attorney or a couple of attorneys and another shareholder who seemed to be involved with them. So we had a conversation, and starting in February, and my basic goal was to find out if these guys were really trying to move the business forward, because I was one who wasn't going to rely upon an Alpine squeeze, even though I'm very familiar with all the details of it. I wasn't going to rely upon it, and I thought the business to work and the stock to work needed some revenue and some business. And the company itself was supposed to be an acquisition company to bring in acquisitions, to bring revenue, et cetera. So started checking into that, and starting in February, I had communication. And at some point in time, I think it was the latter part of February, somebody asked me to hold off pursuing legal action. Now, I had been thinking about legal action for quite some time, probably when I started hearing bad things or things that I questioned about GTI or management, or that caused me concern. And did I have specific facts at that point in time? Probably not. But it's like a spidey sense. You do something long enough and circumstances align, then you have a feeling about something. It might not be right. There might be, it might be reasons for it, but you get this sense. So I had that spidey feeling. So I started to get involved. And I thought when I first got involved, I thought that because of the circumstances that I wouldn't get a huge opposition put up, that the people that were in charge, who were ready to retire, in my opinion, would move on, and we could get this done quickly. And I was approaching it with the issue being their lack of doing an acquisition. And at some point in time, they kind of shifted how it was being handled. As opposed to talking about the acquisition, the attorney said the 10K, hang out for the 10K, because that will basically explain how we're moving forward to undertake an acquisition, and it will be timely filed. And I think the language was, it was a letter from the attorney. It said something to the effect, we don't control the target, but we're moving forward. And then I think there was subsequent communication where he said, we don't guarantee we're doing, we're going to complete an acquisition. But he said, wait till the 10K comes out. It's coming out timely, and the 10K didn't come out timely. And then when you looked at the 10K, it didn't really give you any explanation about any potential acquisition. And that referred to the end of 2023 and all of 2024. I'm not aware of any reference to any potential acquisition. So I thought that information was not accurate. And at that point in time, I was told they were watching my stuff and following my videos. So they were aware of it, and they couldn't have been in the dark. And so if they told you me something, like, for example, if the attorney told me that they timely filed their 10K March 31st, and I put it out there, then maybe somebody took that and made a decision, a stock decision on that. I don't know. Not my intention, by the way. I was just reporting what I was going through, and I had told them that's what I was doing. Anyway, 10K comes, nothing. It's late, and then when the 10K finally comes out, and the later version, which has a bunch of typos in it, turns out was prepared in part by the Borgers company that was put out of business by the SEC because they were deemed a shill auditor. But eventually those come out. But in the meantime, between February and April, and this is all probably going to come out in deposition anyway, so I might as well talk about it. There's a lot of emails that I send out to these guys, a lot being dozens. And I'm asking them what's going on. I'm asking them to explain certain things I've heard. So I might hear there's an issue, and I probably did, I think. I'm not sure, but I think I did. So, if I thought there was an issue with the cash, because there was a large expenditure of cash in 2023, at least appears to be on the books, then I might ask them about them in an email, and I'd said, please contact me. And at no point in time from February to April did anyone from the company contact me, and include no director unless they hung up. And I had a couple conversations with one attorney, and that was the nature of the discussions. And that's as of today. So dozens with very limited discussion. So as time goes on, I'm getting kind of annoyed because I'm getting ignored, and I'm starting to be concerned because why are they not responding? Why do they want to even be involved in this business? They're not doing anything. They're not generating revenue because, as far as I know, in 2022, 23, and probably up to date, they've not generated any revenue. So what are they trying to do? And as time goes on, I grow more suspicious, and my spidey sense starts to become more concerned that there's something that I don't know that's motivating somebody who's a decision maker. That's what I'm thinking. I couldn't tell you what it was, but that's what I thought. And we continue on. Eventually, I could see that the shareholders, when the 10K came out, the numbers were horrendous and frightening. And it appeared, I don't know what they were really intending to do, because they haven't responded, but the numbers look terrible. And there were a bunch of issues that existed in the 10K about shares that were distributed. And if you heard since that 10K, there were a bunch of shares that were canceled because they were either erroneously or inadvertently issued. But that wasn't addressed in the 10K. Probably it should have been, but it wasn't addressed in there. And then there's an issue in there. There was an expenditure or a change in cash from year to year. And again, the problem was there's no revenue. So I don't know what went on, but instead of answering these questions, they ignored these questions. So I supported people getting relief because I thought if these gentlemen and ladies were left to their own devices and no one intervened, they didn't seem to be actively securing a transaction. And if they were continuing to sell shares, and they were when I was talking about this, and I guess they could still, up till that point in time, I was concerned they'd sell shares and they would basically put everybody out of business. So that was my concern, and I have other companies that I've seen where it appears to me that management is not operating for the best interest of shareholders. And I didn't know what happened prior to 2023. I've actually heard good things about management. In 2023, it looks like things changed, and as I got more and more into it, I got more and more uncomfortable about the situation. So eventually there was a movement. I myself filed a lawsuit, I think in April of 2024 here in Southern California, which will be relevant, by the way, at some point. That lawsuit was dismissed the very end of June, and you'll understand why it was dismissed. But it was pending during that time period. And again, I was growing very uncomfortable and was trying to encourage management to do the right thing, in my opinion, to leave and to return anything that should not have been retained by them. And I literally gave them, in my opinion, I gave them dozens of opportunities, and I preferred if they did it that way. I wanted them to leave voluntarily and to make, if there was anything that needed to be cleansed, then do it. But instead of, and I thought there were times that maybe they were going to do that, but in the end they didn't. And so litigation moved, or at least thoughts of litigation moved forward. There was groups that got together, and eventually they, as it turns out, on June 27th, a lawsuit was filed in Nevada by there's about 250 plaintiffs, including myself. There were a bunch of people who decided they wanted to put up shares and wanted to proceed against management of GTII. I'm one amongst many. I did participate in the preparation of the complaint, at least in providing a factual background. I reviewed it, provided comments like that, and in other documents. And I did verify the complaint, so I'm the verifying party, as it turns out. And what I wanted to do is so a complaint was filed. So it was filed last Thursday. I couldn't really talk about it there for a reason, and I'll talk about the reason a little later in this discussion, and it'll make more sense. But this is a verified complaint. It was filed by all the plaintiffs, and the defendants are David Reichman, Kathy M. Griffin, Frank Benintendo, Donald Gilbert. Those are the four. And this is a public legal document. And so generally documents within a lawsuit are privileged. So you could talk about them because it's a public record and you're allowed to talk about the lawsuit, especially if you're a party. And in some states, even discussion and activities prior to the filing of a lawsuit might be protected. So when you file a lawsuit, you talk about it, you might say disparaging, not nice things about your counterparts. There's something called the litigation privilege that kind of protects you. And different states have different breadth of the privilege. And California, where I am, happens to be very broad. So, probably when I started thinking about this, whenever it was in 2023, probably everything theoretically is protected. But be that as it may, I wanted to go over the allegations of the complaint. Now, let's understand. So a complaint is just allegations. It's assertions of conduct that occurred. Doesn't, as you will find out because it's going to really ring true. And by the way, this complaint's a 28-page complaint. And I'll leave it there. It's a 28-page complaint. And it was filed in Clark County in Nevada. It's filed in the business courts in Clark County. Clark County in Nevada has business courts which only do business cases. And the reason why it's in Nevada is because GTII is incorporated in Nevada. So that's the appropriate place to proceed against them and seek relief. It took a while to put these documents together. That's why at certain times I wasn't talking a lot. Didn't want to give the other side too much warning, but they kind of knew what was going on because they were listening and because people have curiosity and might ask questions. And even if I try not to answer overtly, they probably get information by whatever I say. So that's kind of the way I looked at it. Anyway, so this case was filed in Nevada on last Thursday, and that will be an interesting point when you will see. And let me go to the allegations and the claims, because I think these will be the important things. So again, I had these when I was first started having interaction with GTII, things made me uncomfortable. When this action was prepared, there was a lot of investigation done and evidence to support the claims was undertaken. Now, again, like I said, excuse me. I didn't say excuse me, but I'm going to say excuse me now. Even though this is a complaint, this is just allegations, hasn't been proved up. But I know this law firm wouldn't throw out spurious allegations without believing them to be true and without having evidentiary support for them, or at least believing them to have evidentiary support for the allegations they made. So they identified the people. Then I'm going to get to the good stuff. Then they identified the jurisdiction and venue, meaning why are we here? Why are we in Nevada? And I mentioned we're in Nevada because that's where it's incorporated. And there's a bunch of statutes that deal with lawsuits in Nevada. Then there's a bunch of general allegations, and a lot of them deal with the issue of compliance, regulatory compliance, being compliance in terms of filing their 10K, delinquent reporting. And one of the concerns is they didn't file their 10Q. So their quarterly report for 2024 first quarter, as far as I know, has not been filed. I haven't seen it. And that means this first 6 months, I think that's the first 6 months, of 2024, we don't know what's going on, or we don't know precisely what's going on. Although we will find out, and we did get 36 million shares canceled. And by the way, so let me interject this. I don't know how this plays out for the stock, and I'm not making any projections like that. It's not my interest. I just thought best for the company if this management was removed, and I really did think if management was removed, then the company could do business, do revenue, and then I think it would kind of just play out itself and work itself out. I'm not one who's dependent on a short squeeze or expecting that per se. So that was my interest. And when I thought, in my opinion, that management wasn't doing all that they needed to do, at least that was my feeling, that's why I spoke up. So that's just in general. And I don't know, again, there may be an explanation. They just haven't provided it to me. And again, when someone doesn't provide you information after requesting it multiple times, then you wonder. Okay. By the way, this is going to have a little bit of a surprise twist. Not this document, but you will see a surprise twist. We're going to have two back and forth. It'll be interesting. So there's delinquent reporting. So we have the issue about the 10Q, but also we have the issue about the April 10th, the OTC downlisting and what that did. And if you recall, because I think the OTC says, I can actually read it from the document. This is a copy of the filed document, by the way. Because of recurring inaccuracies or concealment in disclosures, related to insider transactions and beneficial ownership. So that's why the OTC downlisted them. For whatever reason, they never corrected it, and it refers to recurring inaccuracies or concealment. So it's kind of scary language. And then we have the issue about the 10Q wasn't filed. I think their excuse might be, and I'm speculating again, not an excuse, but their excuse might be that Borgers, the scumbag auditors who were shut down by the SEC in May, were their auditors, and they're stuck. Even though other companies I know got rid of Borgers much earlier, and if I'm correct, the CEO is both the CFO and chief accounting officer, and I would think, speculating, that he may have had communication with their own auditor. That's just my speculation. So if there's any nonsense going on, I would expect all the officers and directors to know about it, because that's kind of their job, to be aware of what's going on under their control. But I don't know. That's kind of just my speculation. So 10Q's not been filed, and at some point in time, theoretically, that could be a delisting event also, and we don't know when that will happen. And because of the OTC action, that's concerning. So that's why that claim is put in. And there is, I think, if you go to the site, there's an OTC issued a yield sign, which is a negative warning, onto the company's profile. And that's in part because of the delinquent SEC reporting. How do I know that? Because it says delinquent SEC reporting. So the first claim is basically because they haven't done the reporting, it put GTII in immediate jeopardy of being delisted by not reporting. And it says I've made several demands. I've made several demands, and I've made numerous demands for all kinds of things, but they haven't done anything. In my mind, they certainly haven't responded to my inquiries like I would expect them to, or that any shareholder would expect them to. So that's one aspect. The second aspect is fraud and concealment. And here the allegations are that management has grossly mismanaged the company by filing materially false, misleading, and incomplete disclosures, and intentionally omitting material information from its disclosures. And in part, the way they accomplished it, and I'm reading from the document, to facilitate the fraud, they used the sham auditor in 2023 that I mentioned, Borgers, to do whatever work Borgers did. And in May 2024, it says, as I just indicated, Borgers was charged with fabricating audit documentation and falsely stating information and compliance with auditing standards. So the claim here is that in 2023 alone, management made numerous false representations and material admissions regarding compensation, regarding director independence, regarding beneficial stock ownership, and related party transactions. And that relates to the downlisting, where it appears that relates to some kind of insider transactions or issues about ownership, because that's what it seems to suggest. So in April of 2023, the OTC deemed that was such a problem that they downlisted them down to pink sheet status. And again, in the 10K that was filed April 16th of 2024, it's alleged that they falsely represented, among other things, that they had not been paid bonuses and had not received any stock option awards. It then says that similarly in the 10K, they falsely represented that the total annual compensation for the years ending December 31, 2023 and 2022 were of a certain number. So let's say, because it looks like, let me add up the numbers. Let's say the total of all the officers is about $1.3 million for that period of time, 2022, 2023. And let's say in reality, the allegation is, as opposed to $1.3 million in 2022, they received about $12 million. And in 2023, it's actually less. So 2022, it should be like somewhere in the order of $700,000 they should have received, or is reflected on the financials, as reflected in the complaint. But instead of $700,000, they apparently paid themselves or compensated themselves $12 million. And in 2023, the amount was approximately $800,000. And as opposed to directors' fees of $800,000, apparently they were $54 million. So slightly elevated over the $800,000 by factor of 60, approximately. So the allegation is there's something wrong with the disclosures and in the financials, and in reality, the allegation is that management held more than 160 million shares, adding together the shares in 2022 and 2023, and that there's no independent directors. Everybody works under the auspices of a dominating director. That the directors and management have authorized and approved several undisclosed transactions where management, as well as family members, friends, affiliates, and other related parties personally benefited. So again, and here we get to the meat of it. So these are allegations only. Now, again, like I said, I don't believe the law firm that I have been working with would make allegations without believing them to be true, without having what they believe is factual basis for making those claims. But these are just allegations. So here is the allegations of undisclosed transactions. And I don't know. No, I'm going to leave it at that. Some of management's undisclosed transactions, and I'll leave the first one for last, because I think it's the most obscene, really, in my mind. My opinion, if true, if that statement is true, that is the ultimate abuse, in my opinion, in terms of it being an abusive to company. All right, so some of the undisclosed transactions are alleged to include approximately 5,200,000 shares issued to a Reichman family member, and approximately 6 million shares issued to the same family member's entity, owned by one of Reichman's family members. So between the two of them, as it's stated in paragraph 36, that one family member was given approximately 11.2 million shares, approximately. I do not know if that family member still has those shares or disposed of those shares, but that's a lot of shares. And it was likely, or very well may have been at a time, those shares were worth substantially more than they are today. I would be willing to wager that. Okay, so we got that. Next, I'm rounding. Approximately 3 million shares were issued to Mr. Reichman's girlfriend in Beverly Hills. About 2 million shares, 2,000,001, were issued to a irrevocable trust of one of Mr. Reichman's family trusts. 2.2 million shares were issued to another trust, another one of Reichman's family trust. And 21.1 million shares were issued to a Hans and Rosie Memorial Committee, Inc., an Epstein Memorial Charity, and that was 21 million shares that were issued. Again, that's the allegations. And those are all claimed to be undisclosed, obviously questionable. That's the allegation. that they are improper. So the last two I wanted to mention of the and you know, there's been no forensic auditing, so there's been no ability to go in and analyze what really has gone on. Maybe it's better, maybe it's worse, but remember we had that auditor that was deemed to be basically a shill auditor. So unlikely that things are going to improve, although again, you know, if new management comes in and take over, I think we look happy. We're happy. All right, so I've given you a list of those that are alleged to have gotten shares, and maybe there's a great reason for it. And there's other issues that may arise out of here, but we haven't proved them, or they haven't been proven yet, but they will arise, I guarantee you, relating to some of those shares that I just mentioned. The last two categories that are referenced here that at least caught my attention were 550,000 shares were issued to Mr. Reichman's Bentley mechanic. So perhaps a great mechanic, perhaps very deserving. I don't know if that's a business expense. I don't know if Mr. Reichman should be giving GTII shares, and it's not 5 or 6 shares to a mechanic, because again, he might be a great mechanic and he might be doing a great job on Mr. Reichman's Bentley, but that's a lot of shares. So that one kind of struck me, but what really struck me was it's the first one listed, but I left it for last. And I just was struck by this, and maybe you will too. It just to me was like the summary. If you wanted the best example of abuse by management of shareholders, in my mind, in my opinion, and if this allegation is true, this is the best evidence. So Mr. Reichman or someone or management, undisclosed, gave 850,000 shares to Mr. Reichman's personal masseuse. So I'm going to let that sit in. The allegation is he gave 850,000 shares to his personal masseuse. Now, the masseuse may be great. Perhaps. Maybe the masseuse gave massages to all the employees at GTII. I think there was no employees. There was a remote employees. But I was struck when I saw that, and I didn't know about that. So, you know, when I was talking to them and trying to find out what's going on, I didn't know most of those share distributions. And my concerns were not specifically based on any of those. Mine were based just on my dealings with them and how they were acting. But when I saw that, really, I mean, is there any, if it's true, you know, again, these are just allegations of a complaint that's been filed in court in Nevada. But if that's true, and I gave you a whole litany of others that are claimed as undisclosed transactions to various people, if those are true, and if that last one or first one is true, again, I was appalled. Literally, I was appalled, and I'll let you draw your own conclusion. Do we stop there? No, we don't stop there. Let's keep on going. You know, let's keep on going. So we know that in all of 2022, because this is how it's reported, no income, right? No revenue of GTII, none, zero. And I just gave you a whole list of shares that were apparently distributed without disclosure, and we know there was 36 million that were canceled on top of that. I don't think there were those shares. But in May, and no revenue, because that's what they report, unless that they got it wrong and there was lots of revenue. But how about this? May 2022. So I'm reading now from the complaint, and I keep on looking at my phone. I have a reason, and I'll tell you at some point during this conversation. In May of 2022, there was, and this is what the allegation is. There's a company called Internet Capital Online that was owned and controlled by the council of GTII. And there was a transaction apparently where GTII acquired this company that produced zero revenue. And in consideration for this company being acquired, 10 million shares of GTII were given to this company. The shares were then sold by the company that's generated $2 million in cash. And the allegation is that the attorney and Mr. Reichman pocketed the cash, so that they split the cash. I don't know if they split it evenly. But when I saw that they set up it, I mean, if you want to analyze it, it seems to be they set up a transaction. Looks like there's insiders involved in the transaction. I know there was no revenue generated. Sounds like an oddball transaction. And then cash was split, almost like making money out of thin air, almost. And while still diluting shareholders, right? Because if they issued another 10 million shares, that makes everybody else's shares worth less. So I thought that was interesting. It's more than interesting, obviously, being somewhat sarcastic here. And then the next paragraph alleges in October and November, apparently there were two settlements between the company and a couple of individuals. I don't know who they were, who were involved. And in both transactions, apparently, the company paid cash to those parties who made charitable contributions to Mr. Reichman's family trust, and the company received nothing in return. So it appears the company paid money, got nothing in return for the benefit of third parties and perhaps management. And that's separate and apart, but in the same year. The first incident was May of 2022. This one's October and November of 22. Remember, no revenue, and remember when I saw the 10K, I didn't know this. I did not know either of this. And I saw the cash used in operations. I remember when I saw it. And I saw from 2022 to 2023, there was a change in cash of about $4 million. I didn't know they actually issued warrants and they raised additional cash. So apparently, there's cash to be accounted for, apparently. And when I saw that, it made me question a lot of things. So when I saw these allegations, so, as we go on, I'm working with a law firm, a lot of investigation is done pre-filing to make things are accurate. And these come out, it raises concern. So we have like the two items. One is distribution of shares to whoever, didn't give me any, but it seems like perhaps management gave them to everybody else. Of course, I'm joking, but that's what it looked like. And then we have a few transactions where cash is generated, apparently using the assets of the company, and the cash was kept privately. Don't know. That would cause me concern. Then there's claims about self-dealing, conversion, waste, the difference between the losses in 2022 and 2023, 13 million approximately versus 87 million approximately, with no revenue. Some of the stuff we've talked about before. There's a discussion about the cash, that the amount of cash seems to be odd, and where did it go, etc. So those are the general factual allegations. That has been filed in court. It has not yet been served, but I'm sure it's out for service now. And the main allegations are, again, the distribution of the shares, where did they go and why did these people get it? Explain it. I need somebody to work on my shoulders. And the cash and those transactions, especially the one where 2 million comes in, where those monies go. Okay, so that's the first part, and part of the relief that's requested in the complaint, and probably is filed as of now. I just haven't got confirmation, but I'm sure it's filed. That's kind of why we did it this way. Is there also is a request for a receiver and for an injunction. Receiver is, and the receiver, and this thing would be filed sometime after, in the course of events today, would have been filed after. So let me back up forward so that makes sense. So I'm getting ready for today. I spent my time looking at those wonderful jokes. Then I look online, and lo and behold, what do I see? I see a notice from the federal court this afternoon. Who's that notice for? It's for me. Who's it from? GTII. Who sued me? GTII. So I'm preparing to disclose the lawsuit that was filed, several days ago now. And while I'm preparing, I see I got sued I didn't really read it carefully. So I told you, whereas the complaint that I was referring to is 28 pages long, a very detailed matter. The complaint that was filed, I think, is 7 pages long. It lists a few allegations, which I'm not going to get into specifically, although, I mentioned earlier that if you're involved in or contemplating litigation, that's protected. So I'll leave it at that. But the irony of ironies. So I'm preparing to talk about the complaint that we filed a few days ago to go after GTII management and to get a receiver appointed, a receiver being someone to take over day-to-day operations and then move on from there, and to pursue claims for relief, to get shares back, money, etc. And I'm going to talk about it in the public document. So in the meantime, I get sued. How do you like that? You could see that I'm super stressed about it at this point in time. But I thought it was a very interesting tactic, and I will deal with it. And of course, part of the beauty of dealing with this is if you're involved in litigation, somebody sends documents about it, you can talk about the documents, public documents, if it relates to the litigation. So interestingly enough, they accuse me of some false statements. And so if I'm going to confound and confront those false statements, then I would have to state the statement and then tell you why it wasn't false. And so, okay, so be it. After I'm very comfortable about that, we will have another separate live stream where I'm going to go over just the complaint that was brought against me. I thought it was funny in a way, just the sense of timing. And again, like I said, there are ways to respond to that. I do not believe that the law firm was fully informed as to what had been going on in terms of my actions against Reichman and his cohorts. So that goes on. So I'm doing the live stream to tell you about the complaint. I see the complaint. I take a very quick look at it. I spent probably 7 seconds on it. Saw it, read the claims, saw briefly that there was an allegation and there was a time, which is interesting. So I guess I might as well address that. So they sent me a cease and desist letter trying to shut me up. That was their idea. I responded, and in my response, I asked them to identify when it was made, who, I asked them to give me a little more certainty, because some of the allegations they would use, they might say 3 words and 3 dots, parentheses. I don't know what I'm saying. I don't know what the context is of it. So I asked them to state it. As opposed to doing that, they sued me. And in the comments, I saw the one comment, it said what the source was and what the date was, which I thought was interesting. So they listened to me in terms of that they hadn't provided me detail. And they still haven't provided me sufficient detail, but they didn't provide me detail. I just went ahead and sued me. So the irony of ironies, I have an opportunity to reply. Because I thought about it when they served the letter on me, when they sent me that letter. If you recall, they came out to my house at 6:30 in the morning on a Sunday and gave me a copy of a letter they had already emailed to me at my office. And if you recall, the letter had my office address, but they came to my house on the Sunday morning. And I expressed my displeasure. And now they have taken it one step beyond that. And I thought about it at that time, so I've thought about it a little bit. So didn't shock me if they were going to do it, wouldn't shock me if they wouldn't, and I will respond accordingly. And if I can speak about all the allegations, I will let you know. So complaints filed against all the directors in Nevada. And what happens today? So timing is, I use 4 o'clock as a timing because I figured 4 o'clock would give the attorneys enough time to file the application for the receivership, which they, as far as I know, they did this afternoon. So the irony is, I'm here, just to put it in context, I'm talking about the complaint. I find out about a complaint served by me, and then thereafter, the receivership action is filed and an injunction is sought. What will happen next? So that's happening as we speak, live. So very busy day in the courts. So we have a complaint against management, and separate and apart from that, we have an application to appoint a receiver to take over the business, and we have an application for a restraining order to stop basically management from committing waste, to spend money, etc. We also have a request for an expedited proceeding. So, and a judge has been chosen, and after the court rules there will be a hearing, then there will be a hearing, and I will be present at the hearing, representing all the shareholders. And if I need to disclose facts to the court, I shall do so. So I've had a pretty good relationship, just kind of bring up to speed. I've had a good relationship with my counsel in Nevada. I could see how it helps having an attorney working with another attorney, because language is very similar. So I understand what he's asking me, and I probably could more easily provide him what he's asking me. So we have been on the same page. He's a super writer, I believe, writes super well, and the firm he does is well respected in Nevada. So for any companies, any shareholders in the future, if you're going to pursue some company in Nevada, and the way you could do that is, and I know people have talked about proxy fights, whatever, but in Nevada, there's a statute that deals with where the directors, officers are breaching their fiduciary duty, and you can get together 10% of shareholders, you can move to get a receiver appointed. And in a lot of those cases, if you can get the main honcho out of operations, that solves your problem. I know MMAT was based in Nevada. That was just one I've thought of. But I've heard a lot of little companies where I thought management was not doing a service for shareholders, and that if they could get everybody together, that would be a way of doing it. So this is what happened in GTII. We got substantially more than 38 million shares. They ended up canceling, I think, 36 million shares. So that probably reduced the total. But if you get that 10%, and you could put together a pool of money for legal fees, and you could make an aggressive charge, you can make a good attempt to regain control of the company. And again, my position is that we have a lot of adversaries to face as retail shareholders. We face the capital markets and the brokers and the hedge funds and the regulators. And unfortunately, sometimes we face management too. And when we can positively influence the situation and management to do the right thing to help shareholders, we should do it anytime we can. And if in fact there are firms in the country that will help retail shareholders deal with management gone awry, then we should utilize their services, or you should find others that do the same thing. And if you can put together a group, do so. I really encourage you. Again, I think it's really a way of retail taking control over their own future progress. It'll make you feel like you're taking action. And here we are. So now we are in court on GTII. We'll get a judge to rule on the receivership. Has a bunch of stuff that has come out or is alleged to come out that either is true or we will find out the truth. But there are a lot of questions to answer, and they're not now publicly exposed. And hopefully, with a lot of other tickers, this will be a start of a potential model of way it can be handled, where perhaps, because most companies, shareholders have at least some attorneys in their shareholder group, and I can't be the only dumb one to get involved. I'm just joking, but I'm sure there's lots of other attorneys, and I've worked with JR and other people here. But if you could work with outside counsel and present the message of the shareholders, I think that's really helpful. Just my opinion. So next thing we'll find out is I will find out a date of the hearing for the receivership or for the injunction proceedings. That should occur on short order. The documents were pretty substantial. There was the complaint that I think is mentioned 28 pages. There were moving papers that were probably 40 or 50 pages. There were lots of exhibits. So it was a substantial document. Took quite a amount of time to prepare. So the court will set a hearing. There will be a responsive brief, and there may be a reply. I'm guessing, because I don't know the timing yet. I was hoping to have a timing for you, but I will post that when I get the timing. But yeah, it's Vegas. It's in Vegas, but those are the Vegas Alps. You know how in Vegas, what they're known for is they create these amazing tributes to places around the world. There's Paris. Everybody been to Paris. You can see the Eiffel Tower. Well, I don't know if you guys know this, but recently they've built a copy of the Alps, and they keep it snowy year round, which you can imagine the air conditioning cost for that. And that happens to be right behind me right now as I get ready for court here in the Vegas Alps. Anyway, I will, when I know the date of the hearing, which I hope to be very soon, I will let you know. I will be going, and I will be at least reporting about it, if not participating, and I'll try to report as soon as possible. And I'm hoping, because that's what I've been striving for, if we can take over control, day-to-day control over the company, I think that is well needed, appropriate. And you heard the allegations of the complaint. It makes you scratch your cap a little bit. Anyway, if anybody after seeing this has any questions, comments, suggestions, interest, please let me know. I don't know, I'm not going to make any stock predictions or suggestions. You make your own. I just wanted to put out the information. I think it'll be interesting. I think, this certainly could be taken as a positive move forward to change the direction of GTII, because I know that for quite some point in time, that direction has not been positive for quite some time, at least in my opinion. So to everybody out there, I'll continue to report. If I get any news, I'll let you know. But I thought you'd be interested in terms of what the fact that a complaint was filed, the allegations distributions, the allegations of cash, and what happened to certain settlement monies, the claims of self-dealing, etc., the fact that a receivership and an injunction is pending, the fact that I got sued in the same day. Pretty eventful day. And I will keep you guys. Oh, who the attorney is? I'll let you know. I'll let you know who the attorney is. It's a California attorney, the Orange County attorneys out here. I don't have their name handy, but when I go through the document, I'll let you know. It's not a Vegas attorney, but they used to have apparently a Vegas office, but that Vegas office has been closed down. At least that's what it, because when I got the letter from them, I checked them out. Of course, I looked. They had a Vegas office, which made sense to me in a way, but then their Vegas office had been closed. That's not great. Doesn't suggest that their business in Vegas was doing great, or else they probably wouldn't have closed the office. Just a guess, just a wild guess. But obviously, I will keep everybody apprised. Again, the next aspect probably will be might be my response to their complaint and the date of the obviously of the receivership, and obviously underlying this, it's kind of the humorous part, but the allegations that are made in our complaint against those directors kind of deal with the allegations that are made against me in the more minimal complaint that was filed against me. Kind of ironic, and we will see where that goes. I will keep you guys updated. I'll give you all the timing. I try to give you, I try to give it to you as soon as I can. Sometimes, like this, I can't disclose something when I'd like to because we may not want to tip the other side off about what we intend to do. That's why after the complaint was filed, I didn't say anything because I wanted the receivership and application and the request for the TRO to be filed before they knew about it. So they couldn't prepare for it, they would be surprised, and they would have to deal with it on the fly. And I thought that was a strategic advantage. Therefore, that's why I didn't talk about it. So when people ask me sometimes, I give these vague, incredibly vague answers about what's going on. Sometimes there's a reason why I give you an incredibly vague answer. And if I can give you a non-vague answer, I will give you a straight answer. So today, you now know where everything stands with GTII about the ongoing litigation in Nevada against the directors of GTII and seeking damages, the return of shares, disgorgement of money, etc. You know about the receivership application, the request for the TRO, also in Nevada. And you know about the complaint that was filed against me by the Orange County law firm from GTII in federal court in California. So an amazing day. We'll keep you apprised. Everybody be well. Take care. And again, if you have questions, concerns, issues, whatever, let me know. Put it in the comments, and we shall talk soon. Everybody be well. Thanks for your time. Take care. Talk to you soon.